Well, good morning, everybody, and thank you for coming along to Guildhall's Breakfast Bites. I feel like we are short-changing you somewhat. It seems to me the purpose of getting up at 8 a.m. or 8 a.m. To attend a breakfast bite session has to be the bacon sarnies, but hopefully it's not going to be long before we can get back and see you all in person and remedy that misdeed. My name's Allan Roberts, and this morning I'm going to be talking with Charlotte Mallin-Martin on the Supreme Court decision in Royal Mencap Society and Tomlinson-Blake. Charlotte is one of our pupils. She's soon to be on her feet from the 4th of May, so hopefully you'll have an opportunity of working with her. Speaking of short-changed, I feel that somewhat as her supervisor, I haven't had that opportunity that one looks for to pass on wisdom to the next generation, because not only is she our pupil, she's something of our star pupil. There's no doubt you'll have an opportunity of learning for yourself in due course. Charlotte's going to talk about the background to the litigation that led up to the Supreme Court decision. I'm then going to take you through the appellate authorities, what the Supreme Court says, and then looking forward to where there may still be potential future litigation. So I'll hand over to Charlotte for now, and then I'll be back with you in just a moment.
Thanks, Allan. As Allan said, I'll be looking at the relevant factual and legal background to the Mencap litigation. And in particular, when I'm looking at the relevant legal background, I'll be considering not only the legislative provisions that were an issue, but also how those provisions were applied in authorities that predate the Mencap litigation. Looking first then briefly at the relevant factual background to the Mencap litigation. Now, this was a joined appeal with Royal Mencap Society and Tomlinson-Blake, and Shannon and Rampasand trading as Clifton Residential House. Now, in Mencap's case, Ms. Tomlinson-Blake was providing 24-hour care. She was a care support worker, and she would do day work primarily, and that was covered by her salary. But in addition, she would perform sleep-in shifts for specified hours. Now, for those sleep-in shifts, she was kind of primarily expected and to sleep, but otherwise would be expected to keep a listening ear out. And that's certainly a particular term that echoes throughout the litigation. Now, otherwise, Ms. Tomlinson-Blake would be paid an allowance of £22.35 plus 1 hour's pay. Now, if Ms. Tomlinson-Blake was expected to be attending to someone that she was caring for, then for the first hour that she was being called upon, she wouldn't be remunerated. But beyond that first hour, she would be paid at her normal rate of pay. Now, in Mr. Shannon's case, he was employed by Rampasand from about 1993 and worked as an on-call night care assistant. Mr. Shannon was provided with free accommodation, free utilities, and a £50 per week payment. That rose to £90 per week during the course of his employment. He was required to be in his accommodation overnight, but otherwise would need to be available to assist residents in the residential home that he was living in. In practical effect, neither Ms. Tomlinson-Blake nor Mr. Shannon were woken to assist residents that they were caring for. In Ms. Tomlinson-Blake's case, she was called upon 6 times over the course of 16 months. And indeed, in Mr. Shannon's case, he was woken very rarely. The relevant legislative provisions that one needs to consider are fourfold. Now, the 1998 Act is the primary instrument, and the 3 regulations that one needs to consider are those from 1999, as amended by the Amendment Regs of 2000, and the 2015 National Minimum Wage Regs. I say that we need to consider those 4 provisions because in Mr. Shannon's case, the 1999 regs as amended were relevant, and Ms. Tomlinson-Blake's case, the 2015 regs applied because of the date on which Ms. Tomlinson-Blake left her employment. Oh, I apologise, missed the slide there. As I've said, they're the 4 relevant provisions which one needs to consider. And with those in mind, I have 3 key questions which I've been looking at. Now, when is someone actually working? And conversely then, when is someone available for work? Now, I say considering those the relevant statutory provisions takes you a long way towards understanding the Supreme Court's judgment. Now, one needs to understand questions 1 and 2 together. When is someone actually working, for want of a better term? Now, conversely, that's also called when someone might in fact be working. If a case falls on the dividing line such that a claimant is available for work, then the third key question to consider is to what extent is that time to be considered working time for the purposes of the national minimum wage regs? And conversely then, what are the limits or constraints on those provisions? The 1998 Act, is as I said, the relevant primary instrument. Now, Section 1 creates the basic right to be paid the national minimum wage, and Section 2 empowers the Secretary of State to create the regulations that are in issue in this litigation. Section 5 is particularly significant in this litigation, and I say that because it gives the Secretary of State, or rather, when the Secretary of State is making the regulations, they'll need to refer matters specified in subsection 2 to the Low Pay Commission. Now, the Low Pay Commission is an independent body that advises the government on national minimum wage and national living wage. And significantly, in subsection 7 of Section 5 of the 1998 Act, if the government decides not to implement the Low Pay Commission's recommendations in its regulations, or implements only some of its recommendations, then it needs to lay a report before Parliament stating its reasons for its decision. The three relevant reports that were considered in this litigation are those of June 1998, February 2000 and March 2003. And when Allan comes on to look at the decision of Mencap itself, he'll be considering the content of those reports. Turning then to consider the 1999 regs as amended and the 2015 regs. Now, these regulations create provisions for 4 different types of or measures of work that a worker can be doing, and 2 were in issue in the Mencap litigation. Now, when someone is carrying out time work, that's relevant, certainly in the Mencap appeal, because while Ms. Tomlinson-Blake was on salaried hours work during her day shifts, when she was performing sleep and night shifts, they were for a set time and they amounted to time work. In the Shannon appeal, Mr. Shannon was carrying out salaried hours work and he received a weekly sum and in return was expected to do his basic hours for that sum. The definition of unmeasured work was also considered in the litigation, and that's because it's important for understanding some of the previous authorities where carers have been involved claimants have been involved in care work. There is no definition of work in any of the regulations, and so in one sense, one's drawing a distinction that isn't necessarily obvious on the face of the regulations. But the distinction that's been drawn is between actual work, or when someone is in fact working, and availability for work. Now, both the provisions for time work and salaried hours work make this distinction. Now, in the time work context, someone is actually working or in fact working when they're entitled to be paid by reference to the time that they've worked. And in the salaried hours context, the work that you've done under the contract, where you're entitled to be paid an annual salary that's paid out to you in regular instalments, whether weekly or monthly. In return, you're performing your basic tasks that are expected under the contract of employment. When someone's available for work, they are not physically performing a task that's required of them under the contract of employment. However, hours will be treated as worked when the worker is available for work. And that's something that's in issue in the Mencap litigation. So I'm going to spend a little more time now looking at when someone is available for work. Someone's available for work when three requirements are met. The first of those is that the worker is available, but also secondly, and most significantly, it's when the worker is required to be available by the employer. Now, even if they are available and required to be available, they need to be at or near a place of work for the purposes of working. There are two limits on this definition, however, because someone's only available for work in defined circumstances. Now, even if you are available and required to be available for work, time won't count towards kind of computing your working time for the purposes of the national minimum wage legislation, where you're at home during these hours that you're otherwise available for work. The second limit on this definition is when someone's working a sleep-in shift, and that's what's an issue in the Mencap litigation. So what is a sleep-in shift, and when is someone working on one? Now, this definition of a sleep-in shift is present in both the context of time work and salaried hours work. And that requirement is threefold. Now, it requires an arrangement between the employer and the worker. The arrangement is that the worker will sleep at or near a place of work. And then thirdly, that the employer has provided suitable facilities for sleeping. Now, if these three requirements are satisfied, then the time when the worker is available, and so the time that counts for the purposes of the national minimum wage legislation, will be only those hours when the worker is available for the purposes of working. I've noted that there is a slight linguistic difference when one looks at Regulation 27 of the 2015 regulations, and that's when you're exceeding your basic hours under salaried hours work, when you're available for work. And I say there's that linguistic difference because although you're still counting the hours when the worker's awake for the purposes of working, that will be the case even if the worker is required to sleep. In essence, there's no reference to there being an arrangement between the worker and employer. I do query, though, whether that might be a distinction without a difference. Finally, then, to consider how some of those legislative provisions have been applied in authorities which predate the Mencap litigation. I've divided these authorities in two respects. The first of those which look at when someone's actually working or in fact working versus when they're available to work, and also how the definition of unmeasured work has been applied in the care context. In British Nursing Association and Inland Revenue, a 2002 decision of the Court of Appeal, bank nurses who responded to emergency calls from their own homes at night were deemed to be in fact working or actually working for the whole period of their night shift for the purposes of Regulation 3 of the 1999 regulations. It wasn't the case then that they were available for work for that period and so treated as working. They were in fact working. And so that meant that they wouldn't only be working when they were, say, fielding calls from patients rather than even when they weren't responding to telephone inquiries. That analysis was applied in Scottbridge Construction Limited and Borough Down Support Services and Rossiter. And in particular in Scottbridge Construction Limited, that was a security guard working a night shift who was expected to sleep but otherwise respond if, say, any particular emergency became apparent during the course of the night shift. And again, Mr. Wright was deemed to be in fact working for the whole 14-hour shift. And that's because someone was only available for work when they were conducting what's more commonly referred to as an on-call shift. In the decision of Walton and Independent Living Organisation, now unmeasured work was deemed to be relevant to certain workers in the care sector. Now, in Walton, the carer was required to be on hand 24 hours a day to assist the client, and their actual duties, though, took just under 7 hours a day. their pay and their working time would vary depending on whatever tasks they completed, and indeed their pay was tied to the task that they completed and not necessarily the length of time that it took them to complete it. For that reason, their hours of work and their rate of pay would vary significantly. In that sense, then, the Court of Appeal deemed that they were doing unmeasured work, which is any other time that's not work, salaried hours, or output work. Now, that means that the British Nursing Association and Scotbridge were distinguished from Walton in that case. With that hopefully kind of factual and legal background in mind, I hope that's been of assistance. I'll hand over to Allan now, but if you do have any questions on the background to the litigation, then I'll be happy to address those in the Q&A at the end of the webinar.
Thank you, Charlotte. I'm now going to look at the Mencap and Shannon decision, and then we're going to look at how that evolution of the authorities came to the Supreme Court, what the Supreme Court said about it, and where there may still be grounds for some litigation going forward. If you look at the sort of headlines that we've seen about the Mencap decision, you're going to think that to some extent that's the end of the road, but I'm going to identify at least a couple of themes where I think that may not be the case. And indeed, in terms of the headline, you can look to paragraph 44 of Lady Arden's decision. She gave the leading judgment of the Supreme Court. The basic proposition is that they are not doing time work for the purposes of the national minimum wage if they are not awake. Now, that headline is a little bit simplistic, particularly in the reference to them being not awake, and I'll come back to that in just a second. But one of the things that I think is worth understanding is, as Charlotte mentioned just a moment ago, the national minimum wage provisions have different types of work. You have time work, salaried work, output work, and unmeasured work. Now, unhelpfully, in some senses, the Supreme Court didn't break down their analysis by those different types of work and then set out the basis of their decision. In fact, it kind of sort of interwove the points. Part of the reason for that is the focus of the approach, which we'll come to in just a moment. But the long and short of it is that the same analysis will apply regardless of the type of work that's been undertaken, albeit that the reason for getting to that position will slightly differ. Let's just go back a step to the Employment Appeal Tribunal's decision for a moment. Now, there were two cases that went to the Supreme Court, Tomlinson-Blake and Shannon. Both went separately to the Employment Appeal Tribunal, who came to a different decision. In the case of Tomlinson-Blake, President Simler looked at it and decided that a multifactorial approach was the correct way to consider if someone was doing work that should be remunerated as part of the national minimum wage. And she came to the conclusion that the claimant in that case was working whilst she was on call. In Shannon, Judge Peter Clark rejected the claimant's appeal. The Employment Tribunal had found against Mr. Shannon, and he focused on the exceptions to requirements for work, as Charlotte set out that distinction between working and being required to work. And in the second category, there is the home working exception and the sleep-in exception. And Judge Peter Clark focused on those and concluded that the claimant therefore was not doing work. So essentially, broadly similar circumstances, the Employment Appeal Tribunal reaching different conclusions. Both cases then went up to the Court of Appeal, and Lord Justice Underhill gave the leading decision. Now, he again looked at this difference between working and being required for work. Now, if someone is working, then clearly they are to be remunerated for that time. If they are required to be available for work, well, ordinarily they would also be remunerated for the period that they are required to be available, unless one of the two exceptions applies. And what Lord Justice Underhill said is that sleep-in exception only applies if someone is not working. So if they're actually working during that sleep-in element, so if they, for example, have an 8-hour block where they are permitted to sleep, but they are working during that period, we don't need to consider the exceptions, because clearly you're not at that point. They're actually doing some work in that period. And so therefore he looked at whether or not someone could be deemed as working even though they are sleeping. And he said that's not the natural use of language. If someone is working, they are working. If they are sleeping, you can't really say that they are working. And that's an important point to deal with as we see this evolve with the Supreme Court decision. However, what he said, and this is where I think there may well still be some grounds for litigation, is that there may well be circumstances where someone is asleep but still working. However, as is wont of the Court of Appeal, he declined to provide any guidance on when that might be, and we'll see that theme again rear its head at the Supreme Court level. But what he did say is that in the case of Miss Tomlinson-Blake, it was not enough for her to have a listening ear. That's the point Charlotte made earlier, and she's right. It was a consistent theme that went all the way through the litigation. So a worker, as with Miss Tomlinson-Blake, that is asleep but required to keep an ear out in case they need to attend to some on-call scenario, is not enough to say that they are working whilst they are sleeping. Because if you can frame it in that way, if you can say, well, even though they are permitted to sleep, they are working, you don't need to look at the exception to the required to work provision that would mean that they are therefore not to be remunerated. And so there is potentially some grey area as to when someone can be asleep, but still whilst asleep working. And I'll come back to how Lady Arden dealt with that at the Supreme Court level in just a second. In Mr. Shannon's case, it was a fairly straightforward point. He was only found to be working on the rare occasions that he was actually called upon. Now, one other factor of the Court of Appeal decision that I just want to flag up and again return to is an application that was made on behalf of Mr. Shannon by Casper Glynn QC, was to inject an argument under Regulation 22. Now, that hadn't formed part of Mr. Shannon's grounds of appeal, and it hadn't been foreshadowed at an early enough stage. And so the Court of Appeal rejected the claimant's application to rely upon this new argument. Now, the essence of the argument was to try and reclassify the time that someone was sleeping in as their basic hours for salaried hours purposes, such that they would then be entitled to remuneration for the whole period. And then, of course, any additional hours that they work outside of that would then be additional hours that they would also be entitled to receive remuneration. Court of Appeal rejected the application to rely upon that at the last minute. Understandably, the respondent had objected. So then we get to the Supreme Court's decision, and they distinguish between the situation between Mr. Blake and Mr. Shannon. Principally, Miss Tomlinson-Blake was under the 2015 regulations, Mr. Shannon under the 1999 regulations. They focused their analysis on the principle that underlined both of those regulations. In short, in Ms. Tomlinson-Blake's case, they focused purely on the statutory interpretation that should be applied to Regulation 32, and in particular, the two exceptions, homework and sleep-in. And then in relation to Mr. Shannon said, essentially, although the 1999 regs are slightly different, the outcome is essentially the same. One of the central points that underpinned the analysis that the Supreme Court brought to this was the Low Pay Commission's reports. And of course, Charlotte touched upon that earlier, and how the National Minimum Wage Act sets up a statutory process for the LPC's involvement. Now, Lord Justice Underhill had addressed the reports in his analysis in the Court of Appeal, and in particular identified that the Low Pay Commission reports were an aid to construction. And he, in fact, looked at all three of the reports that Charlotte referenced earlier. The Supreme Court, however, were more focused on the first report, and that was presented to Parliament in June 1998, so prior to either of the two regulations coming into force. And Lady Arden, in particular, focused on a passage of the report that I've put up there on the slides. And what she said is that actually it's more than just an aid to construction, because under the National Minimum Wage Act, i.e. the primary legislation, the government is bound to implement the recommendations of the Low Pay Commission unless it provides to Parliament reasons for not implementing it. And since Parliament didn't do that, they must have been taken to have implemented the first report of the Low Pay Commission. And in particular, as you'll see there, the Low Pay Commission drew a distinction between hours where someone is paid to sleep, and in which case that is a matter for the parties to arrange between themselves, and matters where the employee is actually working, and in which case should receive the national minimum wage. And so Lady Arden identified that that being the recommendation, that must be what we see in the form of the regulations in 1999, and then of course later in 2015. And Lady Arden also particularly identified that that recommendation was not specific to any particular type of work. So it wasn't particular to time work or salaried work, and therefore the recommendation must apply to all categories of work. And although the analysis will be slightly different, the interpretation and outcome will be the same. Now, as you can imagine, this was a case in which policy considerations, public policy arguments were advanced, deployed to full measure, and of course the Supreme Court had to grapple with those. And a couple of the things that the Supreme Court did is identify those policy considerations, but also identify what the interpretation of the regulations would not be dependent on. So, for example, whether an employee is subject to an employer's instructions during any particular work is not going to be enough. And of course, that must be logically sound, because the legislation and the regulations draw that distinction between working time, so when someone is actually working, well, of course, they're to be remunerated. When they are required to work, which ordinarily they would be remunerated for, and when the exceptions apply, home working and sleep-in time. So if they are only required to be available and home working or sleeping, then that exception means they're not to be remunerated. Well, of course, the very essence of that is that their employer has required them to be available for work. So the employer has given a degree of instruction to the employee. And so the Supreme Court said, logically, that can't be something that our interpretation is dependent on. Similarly, Lady Arden pointed out that whether the time is beneficial to the employer is irrelevant. And the example that she provided was workers travelling to work. It's not suggested that someone who's travelling from home to work is doing time that is covered by the national minimum wage, even though, in her view, that was to some extent beneficial to the employer. And I'm not sure that analogy truly worked, because I'm not sure you can truly say that someone travelling to work is beneficial, because the logical extension of that is that the longer the commute, the more beneficial that would be to the employer. In reality, it's the person arriving at their place of work that starts the benefit to the employer. But in essence, the underlying principle was the same. And indeed, she said the extent to which the work produces value for the employer is also not relevant. Now, that was particularly important because in Mr. Shannon's case, he argued that the employer, Rampersad, had a regulatory obligation to have a minimum number of employees on site at any one time. And so his mere presence, even if sleeping, was providing not only benefit to the employer, but was producing something of value for the employer, i.e. allowing them to comply with their regulatory obligations. Supreme Court said that is not a matter upon which this issue will turn, because it's not a relevant factor to the interpretation. As regards the policy considerations, now the Supreme Court started out by identifying that they were not going to be looking at reaching a particular outcome based on any particular policy consideration. Essentially, they were going to look at what does the statute mean and what is the effect of that without looking to reach a particular conclusion. And although we see that quite often in judgments, that the protestation that the judge hasn't reasoned backwards, I think you can see from the way the Supreme Court decision has been set out that that is in fact what they did and did faithfully. And so the Supreme Court looked at that central policy consideration of the national minimum wage provisions, i.e. to address supply and demand. The low-paid work sector often has a high supply of workers, and therefore the demand for workers is going to be low because there'll be plenty of people in the pool to draw upon. Their bargaining power is therefore going to be lower, and so they can't collectively bargain for themselves in a way that is going to reach a point of having a particular wage that they might want to achieve, because simply there are too many workers that would be willing to do the work at a given pay rate. And so one of the policy considerations behind the NMW provisions is to try and redress that imbalance. But as the Supreme Court identified, that's not the only policy consideration in play. And of course, one of the arguments, one of the particularly central arguments before the National Minimum Wage Act came into force, is that it would reduce the number of jobs because, of course, employers would not be able to pay the national minimum wage, and therefore either they would reduce the number of their workforce and expect more of them, or indeed it was argued that some businesses would be insolvent and therefore not able to continue trading, which of course would lead to job losses. And so that is another policy consideration behind the national minimum wage provisions. And the Supreme Court identified that the purpose of the Act is not to create a living wage, and that's borne out by that balance of those policy considerations. So yes, supply and demand is an important aspect of the provisions, but that is not the only policy consideration in play. And so while the care sector may well have a number of workers willing to work at that level, and yes, the national minimum wage provisions should come to their assistance, it should not necessarily do so without regard to all of those other policy matters. And so the judgment ratio is then set out in paragraph 45 of the decision. I've put it up there on the slide for you to look at. I'm just going to flag up some of the points that I've highlighted in that purple colour, because this is where I think it might lead in to some further litigation. So if the employer has given the worker the hours in question, so this comes back to my point that actually paragraph 44 headline point, the basic proposition, is perhaps a little simplistic, because it's not about whether the worker is actually awake or asleep. It's about whether or not they have been permitted time as sleep time. So you can't have an employee, for example, have an 8-hour block for sleeping time, say, well, actually, I didn't drift off to sleep for about 2 hours. I couldn't get to sleep, or I stayed awake working. Oh, sorry, I stayed awake reading, and therefore I was working, because they were permitted to sleep in that period. So it's the time that they've been given for the sleep in that matters. She went on to say, in questions as time to sleep, and the only requirement on the worker is to respond to the emergency call, the worker's time in those hours is not included. Now, clue in on the only requirements. If the only requirement, this is the listening ear point, the only requirement is for them to have a listening ear and then respond to emergencies if required, or to respond if they are called upon, that's not going to be enough to mean that those hours are to be remunerated as if they are part of the national minimum wage calculation. Focusing in on the word only, that means if there is more put upon the employee in that sleep-in period, then they may well be outside of the sleep-in exception and therefore entitled to remuneration for the entirety of the period. But again, we didn't have any particular examples of guidance of what would be enough to move them out of that exception. And then identify that unless the worker actually answers an emergency call, so of course, if they answer the emergency call, then they would be remunerated for that time. And in that time, in the event, the time that they spend on that will count towards the national minimum wage calculation. So in short, the period that someone is given time to sleep in is not counted, but if they respond to an emergency, if that is all they're required to do, then the period of time that they are responding will count. A few points to note about the decision. First, this theme that we've been talking about, the distinction between working and available for work, that is the essence of the judgments at the Court of Appeal and the Supreme Court level. But Lady Arden in the Supreme Court agreed with Lord Justice Underhill that there may well be facts where you can say a person is working even though they are asleep. And she gave the example of someone that is permitted to have a nap. Now, Court of Appeal didn't give any guidance as to when you could say someone is working whilst asleep. And all we have from the Supreme Court is that one example. But even that one example is potentially vague. What's a nap? Is it 10 minutes? Is it 15 minutes? Is it an hour? If someone has a nap for an hour in the afternoon, you wouldn't describe them as having sleep-in time. So is it 2 hours? Is it 4 hours? When do we move from a nap to a sleep-in period? Equally important, and to some extent probably fundamentally important to a number of people waiting in the wings, is that the frequency of call-outs is irrelevant to whether or not the exception applies. And so if someone is called out repeatedly, as Charlotte set out earlier, both Ms. Tomlinson-Blake and Mr. Shannon were called out infrequently, 6 times in 16 months for Ms. Tomlinson-Blake and rarely for Mr. Shannon. Some people, of course, however, are called out several times a night. The frequency of the call-outs will not determine whether or not the exception applies. And so you potentially have this odd scenario, don't you, albeit an extreme one, where someone who is permitted to have a nap for, say, an hour might be deemed as still working in that period. But someone who's perhaps been given a 6-hour block to sleep, but was in fact called out for 5 hours, one of them will be remunerated for the hour that they slept, the other won't, even though the outcome is the same, but you've come at it from a different direction. I think in reality, those exceptions, the napping exception or other facts that might say that you can be remunerated under the national minimum wage provisions are likely to be small. I think the Court of Appeal and Supreme Court just didn't want to determine it as absolutely as perhaps they could have done, and at least open the prospect, which is particularly interesting given that the Supreme Court disagreed with President Simler's multifactorial approach, saying that that was wrong in principle, it was undesirable because it didn't create certainty. Well, if you're going to say on the facts there may be circumstances where someone can be deemed to be working whilst asleep, how is that question going to be determined other than taking a look at all of the multiple facts at play? So to some extent, in reality, there might still be a multifactorial approach. What I think the reality of that is, however, is that those categories which the Court of Appeal and the Supreme Court have left open are going to be so small as to say that in general and in principle, the multifactorial approach is wrong. British nursing wrongly decided, as Charlotte identified earlier, as indeed were the other authorities save Walton that Charlotte referred to. But what's particularly interesting about British nursing is that whilst Lady Arden was inclined to express a view about how British nursing should have been decided, the other Supreme Court justices were not willing to go that far. Lord Carnwath and Lord Wilson in particular identified that although they agreed that it was wrongly decided, and of course it had to be wrongly decided, there was a concession made by the parties that Regulation 15 applied. In fact, they hadn't looked at the interplay between Regulations 3 and 15, and in fact it didn't apply, and so the appellate decision had gone fundamentally down the wrong road. What they weren't willing to do is express a view as to what the correct position would be, and so there is a bit of a gap left open in respect of home working. Walton was reinforced, and so even though the Supreme Court looked at the position in respect of timed work and salary work, the outcome is the same in respect of unmeasured work. So where is there potentially still scope for future litigation? Well, 1 and 2 can perhaps be taken together. So as I've identified, both the Court of Appeal and the Supreme Court acknowledge that there may well be occasions when someone can be deemed to still be working whilst asleep. So there's some scope for employees to argue that. Indeed, on the basis that British nursing is no longer good authority, we have a gap in relation to the position for home workers. And I think that's particularly important in this post-COVID world that we're now in. Certainly, Lady Arden referred to the effect of the pandemic on home workers. And of course, many people are now working from home, and there's going to be a difficulty in identifying when are they working, when are they required to work, and when does the exception apply. That's a ground for litigation and authority. The Reg 22 issue, as I mentioned earlier, Mr. Shannon in the Court of Appeal tried to advance a different argument under Reg 22 to try and classify the sleep-in hours as the basic hours. The Court of Appeal refused the application to rely upon that argument. The Supreme Court were asked to deal with it as again and said, no, it's not appropriate. We haven't had the Court of Appeal's reasoned decision on that issue. It wouldn't be right for us to hear it new, not least of which would also have to have findings of fact. So in theory, the argument that's put forward on behalf of Mr. Shannon could still be run by someone anew, and then, of course, if need be, that be appealed. In reality, I don't see that happening other than by someone very brave. Lord Justice Underhill, whilst not having to deal with the point, expressed a preliminary view that it was, in his words, a bad point. And indeed, if you look at the analysis, I think perhaps it probably was grasping a little at straws. So possibility, but probably not something that we're going to see too much of in the future. Working time regulation claims. Now, this certainly is going to be a battleground, particularly as regards to adequate rest breaks. The Supreme Court were clear in identifying two things. One, that they were not seeking to achieve a particular outcome. They were specifically looking at the regulations themselves, what those meant, how they should be interpreted. And they also identified that the position is not the same under the working time regulations, not just because the wording is the same. In fact, we can logically agree with that. The wording is not only different, but the genesis of those legislation provisions are different. So in terms of the working time regulations, you've got EU legislation that underpins it. You also have a different process by which that legislation has come into being and different language that has been used. And so the analysis might be the same. Equally, you don't have the LPC reports that underpin what the working time regulations are doing as regards its implementation. So the working time regulations is likely to be the next battleground for these types of claims, particularly, I would imagine, in the care sector. Finally, and this is where I think probably the biggest area for litigation is going to be, is record keeping cases. Now, there is an obligation under Regulation 59 for employers to keep records of the hours worked, but I think this is likely to have been a gap. Indeed, I've got a case of this kind already, a care worker that is required to live in for 14 days in a stretch and be available for 24 hours, essentially working for most of that, and then an 8-hour chunk of sleeping time. And she would regularly attend throughout the evening, whilst there are records for each time she attends a call out. There's no records as regards the amount of time that she spends on each of those call outs. And so that's going to be a classic ground for battle, because naturally employees are going to be trying to say, I spend X number of hours attending that call out over a period of an evening, multiply that by however many evenings I've had to do it. And of course, employers are going to want to try and limit the scope of that. And of course, there's going to be a blur as to when they're actually working, because if someone attends a call out and then has to go back to their room and may well sort of meander, they may go and make themselves a cup of hot milk to help them get back to sleep. Where is the cutoff point? When have they stopped dealing with the call out, and when are they back on to the sleep-in exception? And if there aren't clear A, records of that, and B, clear markers as to when it starts and stops, you've got yourself fertile battleground. And of course, you take that on an exponential level out towards not just that particular employee over that particular time, but that many employees and that many employers, that you could see that as potentially being where the next line of battle will be. So I hope that's been helpful. I hope that Charlotte's background to the litigation, the law and the facts, and my analysis of the Supreme Court decision and where we may be going in the future has proved useful. Of course, if you have any questions, please do open up your microphones and cameras and share them with us. Of course, you can also put them in the chat window if you would prefer, or indeed give us your thoughts. Of course, this is just our opinion, and it may well be that you have different views about the decision, or indeed you may well have different views about what we're going to be looking at in the future. But in any event, thank you very much for coming along, and it's been our pleasure. Hopefully we can see you soon in person. Take care. I'd be interested, Louise Hayes has said, I'd be interested to hear your thoughts, read the decision in light of the Uber judgment. Well, I have to say, I thought the Uber judgment might have foreshadowed that the Supreme Court would have gone in the favour of the workers. I know many people were taking a different view, because I think actually they've reached the right analysis. And I think that if you look at the legislation, it is pretty clear that that distinction has been drawn. But when you consider the sort of mood of the Supreme Court and the way that they've been very good at protecting employee rights as they did in the Uber case, you might have thought that they would have adopted President Simler's multifactorial approach. So to that extent, I was a little bit surprised that it did go the way that it did.
I agree, certainly.
I certainly imagine some of the care workers, indeed the care worker client that I had, gained some degree of confidence when they saw the Uber decision and thought that they were going to be the next sort of batch of workers that would be sipping champagne after they've reached a decision in their favour. But sadly, that wasn't the case for them. But I think the care sector as a whole has breathed a sigh of relief. I imagine that they probably were on tenterhooks after the Uber decision, and now can safely say that, of course, for the vast majority of that time, even though there may still be that battleground about whether someone is attending work, what records have been kept, ultimately, if someone's got an 8-hour shift, one would assume that the vast majority of that time is now going to fall within the exception. And therefore, even if there is ongoing litigation, the value of it is going to be substantially lower. And so the care sector, in terms of the care providers, no doubt breathe a sigh of relief, having been probably alerted to the Uber decision in the way that the wind might have blown.
I agree. Certainly on the in the Mencap litigation, it's a clear case of statutory interpretation. Whereas at least in the Uber litigation, when one's looking at Section 230 of the Employment Rights Act, that's only the starting point. The incremental case law as it's developed since the 1996 Act was particularly relevant. It's not necessarily applicable to the Mencap litigation when one's looking at the relevant legislative provisions.
Well, that's such an interesting point, because, of course, in terms of analysis and the statutory interpretation techniques that had to be applied, Lady Arden was very keen to point out, in fact, there was a passage that she quoted from, I forget the author, who looked at the sort of logical approach that must be applied in interpretation techniques. And she drew a distinction between the court's powers in the case of common law and declaring what the law is, and statutory interpretation when one is looking at Parliament's intention. And of course, with the national minimum wage provisions, there's little room for manoeuvre. They must apply what the legislation says. And indeed, with the Low Pay Commission, ascertaining what Parliament's intention is pretty clear, because there is that statutory obligation to implement their recommendations unless the government sets out its reasons to Parliament. So they could be quite clearly identified. The Parliament's intention could be quite clearly identified. Whereas perhaps with other legislation or other common law principles, the Supreme Court may be in less of a straitjacket. I did kind of get the sense that they weren't necessarily happy about that being the right outcome. And they were at pains to sort of express their view about the benefits to society of care workers, and that no doubt everyone will recognise that benefit. But they were faithful, and that's why I say perhaps uncharacteristic. You do often see judgments say, I don't have any preconceptions. I'm going to hear the arguments and then I'll make my decision. And we may well raise a cynical eyebrow to think, well, I'm not sure that's right. It does rather seem you've reasoned backwards. I think here the Supreme Court have been faithful to that approach, and they've simply applied what the legislation says. And if there's to be any shift in policy, that should be a matter for Parliament. It looks like everyone's now departing, so thank you very much for attending. For those still left, we're going to wrap it up there. We will post a copy of the video on the website if either you want to have another look at it, or of course if you have colleagues, and we'll also put up the slides. But for now, thank you, and we look forward to seeing you again soon. Take care, everybody.
Thank you very much.